Hello, good afternoon. Okay, today we come back to our Live and Learn. Okay, I changed the name to Live and Learn. Okay, instead of Lunch and Learn. Okay, because we are not going to proceed at during lunchtime. All right. So live and learn, because we live and we learn our things. Okay, that's how we change its name, Live and Learn. Okay, hope you enjoy it. Hope you benefit from the sessions. Today, I will share about land caveats, specifically on lodgement and removal, not touching on any other things lah. Okay, we are zooming on the lodgement and removal, right? Okay, next slide. Okay, so outline of this session, I will touch about types of land caveats that we have, and process of entering. Okay, lodging means you enter the land caveats, and what is cavitable and non-cavitable interest, and the removal. Okay, so next slide. Okay, according to the National Land Code, okay, we have few types of caveat, okay, land caveats. Of course, the first one is the registrar's caveat, also known as the land administrator's caveat, because it is entered by either registrar or the land administrator. Okay, the provisions for the registrar's caveat is contained in section 319 to 321 of the National Land Code, if you read that code. So we say entered by registrar or land administrator means they are the one to take the initiative to enter. Okay, so you must ask them, what's the reason for them to entering? Of course, they cannot simply enter a caveat on other people's land, right? So these are circumstances. One, to prevent fraud or improper dealing. If they have knowledge, okay, there's going to be fraud going to happen to that land, okay, regarding that land, or improper dealing. So registrars can take the initiative to lodge that caveat. Okay, or protecting the interests of the federation, okay, or the state authority, because no registrars is for the government. So they, in order to protect the interests of the government or the state, okay, or person under disability, okay, or the under minority, mental disorder, unsound mind, to protect the interests of these people, okay, they also can enter a registrar's caveat. Okay, and to satisfy debt of the government, like due to the government. Okay, you owe government debt, what loan, and they can, if you happen to have a land, the registrar can also lodge caveat on the land. Why is this caveat so powerful? Okay, why they can lodge here for these circumstances? Okay, next slide. Okay, we will go into that later. So how do you enter? Okay, how does the registrars enter the caveat? It's pursuant to Form 19F. Okay, if you see Form 19, there's a lot. Okay, ABCD until a long list of Form 19. Okay, various forms for caveats. So for registrar's caveat, remember, is Form 19F. Okay, it's only effected when after you lodge, there's this endorsement. Okay, registrar will endorse registrar's caveat entered, will chop there. Okay, endorse, that means they will chop on the title, and they will also serve a notice. That means they need to notify the landowner, because you are privating on, you are lodging a caveat on other people's land. So you need to let the owner of the land know that you are entering a caveat. All right. So just now, why this caveat is so powerful? Because once you enter the caveat, it will prevent registration of any other instrument dealing with the land. For this, registrar's caveat is even more powerful because it will prevent registration even before the entry of the registrar's caveat. Okay, because for private caveat, it will prevent subsequent dealings, right? But it will not prevent dealings which are entered before the caveat. But this registrar's one is so powerful, it can prevent even before the dealings. Okay, those dealings that come earlier before the registrar's can also be prevented. Okay, that's how it's powerful is. So, and the other thing is that, okay, normal caveat, you will have an expiry of 6 years. Registrar's caveat, no expiry. It can last 10 years, 20 years until the registrar cancel it. Okay, so a registrar can cancel it by its own motion or by the landowner application. Okay, or get a court order to order the registrar to remove that caveat. Okay, next slide. All right, private caveat. Private caveat is the one that we come across most often. Okay, Section 322 to 329 of the National Land Code. So who can enter private caveat? Just now, registrar's caveat, only the registrar and the administrator can enter. Normal people cannot enter. But this is meant for normal people, okay, like us. So section 323 got list down who are the people can enter private caveat. Okay, if you are claiming title, you say the land is mine. I have registrable interest in that land. I have a share in that portion of the land. Or I'm beneficially entitled, okay, under any trust, then I can enter. Or you are a minor, okay, you need to have a guardian, your next friend. Minor, you cannot act. So you need a representative on the behalf of the minor. We call that guardian or next friend, yeah? So then that person can enter, okay, on behalf of that minor. So how do you enter private caveat? 19B, yeah, 19B. So in order to enter, you have to state what's your claim lah. Your reason for entering, not simply enter, yeah. Okay, you must have grounds. Either your ground will be 1, 2, 3 lah. As I explained earlier, you have an interest in the land, or you are beneficially entitled, you are guardian, okay, acting for the minor. These are your claims, all right? Next slide. Okay, so you have also, okay, apart from stating the grounds, okay, to enter the caveat, you need also to state whether that caveat is to bind the land itself or only a portion of the land, okay, only a particular interest in the land. You need to state that specifically, okay? People sometimes half share or particular interest only, okay, or portion of the land only, not the entire land. So you also need to state the nature of claim, okay, for entry of private caveat. Last known address of the landowner, and an SD. You need to affirm an SD, okay, stating your grounds by way of an SD. In relating to part of land, okay, if your claim is only a partial of the land, you need to have the plan showing which part of that land you mark it. Okay, meaning that means it's not the entire land, but your interest is only actually one part of the land. Okay, so you need to mark that in red. Okay, so the entry will also be effective when the chopped private caveat there, the endorsement on the registered document of title, yeah. And then, as usual, the registrar still needs to inform the landowner. Again, because you are entering private caveat on other people's land, so registrar, the land office need to inform, hey, your land is being caveat, huh? All right. Okay, next slide. Okay, you enter, you also can withdraw now, right? Okay, the caveator. The caveator is the person who lodged the caveat. Okay, he can lodge that. Of course, he can also withdraw. Right? Then how do you withdraw? You file a form 19G. Okay, to withdraw the caveat. Then removal. Okay, removal and withdrawal not the same. Huh? Withdraw is by that person, the caveator himself. Okay, he lodged, he himself go and caveat. But removal is not that caveator himself. Okay, it may be that landowner or any other person whose interest is affected by the private caveat. He will apply, okay, to registrar to remove for the private caveat through the form 19H. Usually it's the landowner. Okay. Apply to the registrar. So registrar again will serve notice, okay, in form 19C to the caveator, right? And then caveat will be removed upon expiry of 2 months, okay, in form 19 after the service of 19C, unless the caveator obtain the court order for extension. All right, so this is quite procedural, removal by registrar, okay. After 2 months, okay, nothing objection from the other side, then we will remove that caveat. This is application to registrar, okay. Next one, next slide. Other than registrar, of course, okay, if you are not the landowner, if you are any other person who are aggrieved, okay, by the private caveat, affected because of that private caveat, then you need to apply to court, okay, for an order, a court order to remove the caveat. Okay, this is provided under section 327 of the National Land Code. Then private caveat also, if there's no removal, it itself will also expire 6 years, okay, from the registration date, unless you withdraw earlier or unless removed by the court earlier, okay. Otherwise, it will still expire, okay, at the expiry of 6 years. This is provided under section 328 of the National Land Code. Next slide. Okay, there's some issues here regarding private caveat. So one of the questions, okay, there are 2 cases that you need to know when you are dealing with private caveats. Can a private caveat be entered on part of the land? Not the whole land, but portion of the land. Can or not? Okay, this was asked in the federal court decision of Chopek Ha against Farling Properties. This is one of the landmark case, okay, that you need to know when you are dealing with private caveats or issues regarding private caveats. Okay, so in this case, it was asked, okay, the question posed to the court whether a person claiming an interest in only part of the land could protect his interest by entering the caveat over the entire land. Okay, but in this case, a little bit of caution needs to be made because it refers to the old section 322. Okay, 322 sub 1, there's the proviso there. Okay, if you see the proviso today is the new version already. Okay, but before that there was it was already amended. But the old proviso, it says that provided that such caveat shall not be capable of being entered in respect of part of the land. Okay, you see this sentence proviso sounds like so straightforward. Actually, the effect is not straightforward. Does it mean, what does it mean? Can the caveat be entered? Okay, if you only your interest is only part of the land? It seems like cannot. Okay, it seems like the wording is cannot, right? If you read it literally. Okay, next slide. So the court in this case, okay, they also agreed that this actually the interpretation is not clear. The proviso can mean 2 things. So either that no caveat can be entered at all if your interest is only partial, or 2, caveat can be entered on part of the land. Okay, the effect of which is to bind the whole land, but provided that the caveator must first show that he has a cavitable interest in the land, okay, on that portion of the land. Okay, provided he can show that he has cavitable interest, then he can enter on part of the land, okay, which had the effect of binding in the entire land. All right, so the court in that case agree. The answer yes. The question just now that can a person enter on private caveat, okay, on the entire land if his interest is actually only a partial interest in the land? Court said yes, okay, provided that, as I said, okay, court follow this second one up. You can show that you have a cavitable interest, then you can enter. All right, so because the rationale is that if you say that the caveat, okay, if your interest is only partial and therefore you cannot enter caveat at all, what it means is that, okay, it would protect Okay, the proviso protects a caveat to protect and prohibits a caveat to protect an interest in part of the land, would mean that dealings in part of the land are permitted. National Land Code permit, right? But they cannot be protected by caveat. So it doesn't make sense. Okay, you allow such dealing. Let's say tenants, not tenancy, it's a leases or easement, okay, part of the land, but they cannot be protected. So it defeats the purpose of having the dealings. Okay, so the court finds that, okay, no caveat at all is not, it doesn't seem sensible, it doesn't seem reasonable. So court favors the other interpretation. It means that the proviso means that you can enter, okay, provided that you must show that you have a cavitable interest. Okay, next slide. Okay, the other issue, okay, this is another landmark case. Can a private caveat be entered on a tenancy exempt from registration? Why is tenancy exempt from registration? Okay, tenancy, okay, any tenancy that is 3 years, not more than 3 years, 3 years or less, you do not require to be registered with the land office. Okay, any tenancy that is more than 3 years, we call it a lease, it needs to be registered with the land office. All right. So the Court of Appeal in this decision of luggage distributors against Tan Ho Teng. Okay, this is a renting, okay, landlord-tenant issue. So the respondent in this case is the tenant renting premises from the appellant for 2 years under a tenancy agreement. There was an option under the tenancy agreement to renew for another 2 years, but it's not stated in the body. It's stated only in the recital. So the provisions are not clear, although yes, it is, okay, they mention an option to renew. So subsequently, the appellant, the landlord, sold it to third party. Okay, so this tenant respondent go and enter private caveat on the ground that he has a cavitable interest. Okay, he said that it becomes a lease because 2 years plus 2 years renewal means 4 years. So he has it becomes a lease, so which is an interest in the land. A lease is an interest in the land, right? So therefore, he's entitled to enter caveat. This landlord not agree. Okay, go and apply to remove the caveat. Next slide. Okay, so appellant's ground that no, he doesn't agree. Okay, respondent, this tenant has no cavitable interest because it's only 2 years period. Okay, so the length of tenancy for a fixed period, you should not include the renewal period. You shouldn't include the option to renew. Okay, so it did not state clearly, okay, in the time for exercise of the option. So the respondents' ground that they had enlarged, the tenants, on the other hand, argued that no, they had enlarged the term of tenancy to 4 years instead of 2 years. So they are entitled to registration. So it becomes a lease, okay, which is capable of being registered, is registrable interest. So therefore, it's a cavitable interest. Okay, so each have their own reasons. Next slide. So Gopal Sriram, okay, in this case, decide that the tenant did have an option to renew the tenancy for 2 years period, and the option was not void. Okay, it's certain. However, okay, the section 224B of the National Land Code says that you cannot include the option for renewal when you are counting, okay, you are calculating the length of your tenancy. If your tenancy is a 2 years tenancy, it's 2 years. You cannot include that 2 years renewal, become 4 years. No. Okay, so it's 2 years, but renewable for another 2 years. All right. So regardless of whether the option renew has been exercised by the tenant, it doesn't matter. It's still, if it's 2 years, okay, it's been renewed for 5 times already, it's still a 2 years tenancy. But renewed, okay, renew and renew. Okay, so you can't simply add the option because tenancy don't simply become a lease. It cannot be. It's a different process, yeah, different type of agreement. Okay, so the exercise of this option by the tenant, yes, tenant have an option, but he's only entitled to exercise it, option to renew, upon the expiry of the 2 years period. Okay, so when you have an option to renew, you must state clearly in the tenancy agreement when to exercise this option. Okay, the tenant cannot exercise it anytime as he like. Option renewal, you must either state clearly when to exercise this. Okay, upon which, okay, usually parties will agree to exercise at the expiry of the first term. After the expired of the first term, then only you exercise the renewal. Okay, section 3231 of the National Land Code only allows registrable interest. So this tenancy here is still a 2 years. Okay, 2 years tenancy, it does not create a registrable interest. It's still a contract. Okay, it's still a contract. It doesn't create any interest in the land. Okay, so the court held that sorry, it's not a cavitable interest because it's not interest that you can register. Okay, okay, next slide. So applying this ratio provided by Gopal Sriram, we know we call it a 3-stage test. Okay, this luggage distributor introduced this 3-stage test where the party may lodge a caveat are those having dealings with particular interest in the land. You must either have registrable title, registrable interest such as a lease, charge, or easement, or a claim to an interest, okay, that falls under these two. Okay, next slide. Lien holders caveat. Okay, this is a third type of caveat. Section 330 to 331, okay, of the National Land Code. Who may enter this lien holders caveat? Lien holders is someone who holds title to the land, okay, but does not execute charge. You only got title deposited with him as security. Okay, for maybe for some reason they did not execute any charge. So for those type of category of people who has the title but no charge, they may enter lien holders caveat to protect their interests lah. Okay. So the procedure for lien holders caveat is to through Form 19D. Okay, must supported by production of the issue. You must accompany it by the title, and then on receipt of the application, the registrar to enter the caveat. Okay, and also notify the landowner. Okay, Form 19A. So it only take effect when there's endorsement chalk on the registered document of title that lien, okay, caveat lien. Next slide. And the statement, okay, stating that the caveat binds the land or a lease, or who is the caveator, a time, okay, these are particulars that you need to be supported when you enter lien holders caveat lah. So lien holders caveat have the same effect as a private caveat. It will stop, okay, subsequent dealings, but it also does not lapse, okay, at the expiry of 6 years, just like the registrar's caveat, okay, it does not lapse. Okay, determination, that means you terminate lien holders caveat. Yeah, you can withdraw it. Okay, of course you can lodge, you can withdraw by the caveator. Okay, the people that the person who lodged that lien holders caveat can withdraw it. Okay, by writing to the registrar, and the land subject to lien holders caveat is sold where it's sold under order of the court, auction usually. Yeah, Then court will issue a certificate of sale. And you present that for registration, okay, after you pay the balance purchase price, it will be deemed that the land, next slide, being presented, okay, by with the consent of the landholder. Okay, this it will deem to be with the consent of the landholder. So upon registration of certificate of sale, the entry of the landholder's caveat will be cancelled. Of course, okay, you cannot hold on to the caveat already. So the court may order cancellation, okay, if it is satisfied that the caveat ought not to be entered. This upon application, okay, if someone applies, okay, to cancel the landholder's caveat. All right, next slide. Another one, the fourth one, is the trust caveat, section 332, okay, 333 to the National Land Code. Okay, who may enter this trust caveat? Okay, the word is very clear, like trust caveat, of course, must be the trustee, trustee of the land, okay, trustee of the land interest, beneficiary of the land, okay, or the interest in the land. Okay, interest will be maybe must not be title, okay, maybe lease, maybe easement, maybe charge. Okay, so procedure form 19E, you must produce, okay, documents to support, okay, the title. Then the entry effective upon endorsement, okay, they will also chop caveat with the bracket trust. Okay, next slide. Okay, the effect of this, okay, once you enter the trust caveat, it will prohibit the entry of any instrument of dealing, any claim to the benefit of tenancy exempt from registration, and any landholder's caveat cannot, okay, it will not accept. Okay, but same as the landholder's caveat, it does not lapse expiry of 6 years. Okay, looks like only the private caveat will lapse at 6 years. Okay, the other, all the three, not lapse. Okay, they will continue in force until the registrar can cancel it. Okay, I remember for trust one, trust caveat, you need two petition by trustee and the beneficiary to cancel it. Next slide. Okay, cavitable interest. We have heard this in cases where dispute arises. Okay, when the caveator, okay, the person who caveats the private caveat, the caveats, they need to show his cavitable. I have that cavitable interest. Not any interest is cavitable. Okay, so what types of interests are cavitable? Okay, means capable of being registered. May not already registered, but capable of being registered. Example, enter into SPA of property and paid deposit. Like normal, okay, we buy property and we pay deposit already. Then we are entitled to register, our interest is registrable because we are going to take ownership eventually, okay, upon paying the purchase price, right? So once you pay deposit, yes, you have a right to caveat, okay, to lodge the caveat. Okay, this is what established in this case of Micron Engineering, okay, against Goh Hu Yin. Or you have a beneficial interest in the property that has been registered in the name of other than the beneficiary, okay, of a you put the party name, but actually you have the interest. You are the beneficiary under that of the property. Okay, if you can show that, yes, you can also, you have a cavitable interest. This is established in this case of Cheng Chung Hui. Okay, or you are chargee of a property pending registration of your charge. This standard procedure where the bank, okay, you go apply for loan from the bank, and there's a period of time again before the transfer of, the registration of charge can be registered. So during that period also, the charge, okay, the bank will also lodge a private caveat, lodge a caveat. Okay, this is what is established in the Standard Chartered Bank against Yap Sing Yok. Next slide. legal action under National Land Code for a declaratory order that affect the rights on the property, you also can lodge a caveat. Okay, that's established under the case of J. Raju against Kongit Bank. Okay, if you have cavetable, we also go and see what is non-cavetable. Next slide. Okay, non-cavetable, first and foremost, okay, a contractual term does not create a cavetable interest. This is very important. Okay, you must know contractual right, okay, contractual interest, and proprietary interest. Okay, to enable you to caveat, you must establish you have a proprietary interest, not a contractual interest. Okay, so it must be an interest that is recognized under the National Land Code. For example, okay, you return of forfeiture deposit after you terminate the SPA, then you go and lodge the vendor's private caveat to get the deposit. No, that is not a cavetable interest. Okay, you a judgment creditor got that against the landowner to recover. Okay, you know that you got land, right? I go and lodge private caveat. No, because he's claiming is for money. You owe me money. Okay, and then I know that you have land. I have no right to caveat because that's only contractual. Okay, nothing to do with the land. I don't have any interest in the land, so you don't have cavetable interest. Okay, that's what also established in the Standard Chartered Bank against Yap Sing Yok. Yeah. Next slide. Entry of private caveat to recover balance purchase price due. This one also no cavetable interest. It's only contractual interest. Not even contractual. Okay, you don't even agree to allow to caveat, okay, to cover your balance purchase price. So this one no right to caveat. Okay, so just now we said cavetable interest is interest that is registrable, capable of being registered. Okay, so in this case, score option, okay, it's a 2001-2 federal court case. Established what is registrable means an existing interest in the land or having a right to such existing interest that cannot include potential interest. Okay, it must be existing interest at the time that he entered the caveat, not any rights in the future. Okay, next slide. Okay, does this mean that no registrable interest, no caveat? General rule, yes. But of course, there are exceptions. Okay, you are claiming to be beneficially entitled, yes, then you can. Guardian or any of a minor, okay, that means on trust. And there's exception. Okay, and this case of Wong Kwan Tan against Gambut is a landowner who lodged caveat on 2 grounds. Okay, one is that the land was held by interest for him, and then the balance purchase price was not paid. Okay, next slide. So the landowner lodged caveat because he has not received the balance purchase price, and interest here refers to the balance purchase price. So as we have said just now, the non-cavetable balance purchase price is not a cavetable interest. It's not something recognized under the National Land Code. It's purely contractual, right? So purely contractual cannot be a cavetable interest. Okay, so no choice. Okay, you have to remove the caveat. Okay, there's no cavetable interest. So the caveat cannot be removed. It cannot be remained. Yeah. Next slide. Okay, this is another important issue, okay, regarding caveat. Removal of caveat. There's a lot of issues regarding this. Okay, section 327 of the National Land Code provides that any person aggrieved by the existence of a private caveat may apply to the court for an order for its removal. Okay, any person, not only the landowner, okay, any other person. So upon being served by order of the court, the registrar needs to cancel the entry. Okay, on the register. This is when you already obtained an order for removal of the caveat lah. You have to serve it on the order on the registrar to get it cancelled. Okay, next slide. So, it must be a aggrieved person, okay, to apply for removal. So he must show that he's an aggrieved person. So who are these aggrieved persons? It is not properly defined in the National Code. So based on case law, what does it say? Okay, so in this case of Ganding Maju, okay, against KS Property Development, it says that a man who has suffered legal grievance, okay, a man against whom a decision has been pronounced which has wrongfully deprived him of something and wrongfully refused him something or wrongfully affects his title to something. Okay, next slide. Against this Wu Shu Chen against Raja Zainal Abidin, 97 case, the word aggrieved must be given ordinary meaning. To be aggrieved means that one is dissatisfied or adversely affected by a wrongful act of someone. So an aggrieved person is therefore a person whose legal right is adversely affected. So we must use adversely affected by the wrongful act of another person. Next slide. Luggage distributor, okay, just now we have gone through this, a 3-stage test, which must be considered, okay, before deciding whether a caveat ought to be removed. Okay, so the only parties who are authorized to lodge a private caveat are those who may effect dealings, okay, of either a registered title, registered interest, or a claim to that interest, okay, a land or interest. Next slide. So in score options, Sdn Bhd against Maxland, 2012, okay, the appellant's landowner entered into a joint venture, okay, come project development, okay, with the respondent. So there is a JV agreement signed, okay. So there's this piece of land, but the JV agreement is to one part of the land. The other part of the land is actually sold to another company, not in the picture. Okay, but when they sign the agreement, the landowner grants certain rights to this respondent to develop the land, right? Including a right to lodge caveat on the land. Okay, next slide. So this developer go and enter caveat on the entire land, including the next door land. Okay, so there's dispute arise, okay, which caused the termination of the JV agreement because they are not able to launch the project by the deadline. So there was a private caveat lodged ready by the developer. So the developer commenced an action for wrongful termination, okay, but the landowner on the other hand applied to remove the caveat entered by that developer. Next slide. The respondent applied for extension of time, okay, for the caveat until final disposal, okay, against the suit. And the application was dismissed. The court didn't allow. Federal court, okay, it went to a court of appeal, allowed, but again in the federal court, appellant appeal, okay. Next slide. The court held that the caveat is a creature of the National Land Code, so can only be lodged by a person who has a registrable interest under the National Land Code. And although the appellant has conferred numerous rights, okay, the landowner has given rights to the developer under the JV agreement, but the rights are contractual rights. It does not create any interest of the land to the developer. The developer does not have any interest in the land. So it's purely contractual. So the interest in the land must be present interest. It cannot be future interest. Okay, in the JV agreement, actually, it was also stated that the developer, okay, upon building developing the land, okay, with buildings, they are entitled to purchase some of the units it developed and transfer it, okay, but that right has not yet accrued, okay, at the time when the caveat was entered, because the house was not even built yet, okay, this was something in the future, upon completion only God can transfer, right? So he has no right yet, okay, when the caveat was lodged. Next slide. Okay, 2021, there were two cases that we shared in the SharePoint. So one of these is Lin against EcoWood International Berhad, where the plaintiff purchaser who paid a full purchase price. The question in this case is that whether purchaser who has paid a full purchase price, but transfer was rejected because there's a caveat lodged, is an aggrieved person. Okay, the answer is yes. Okay, in this case that this purchaser bought the land and then go and get loan from the bank. Okay, there are 2-3 times that he made the search, there was no caveat lodged. Okay, they advised the bank for release ready just before transfer. Okay, bank release ready just before transfer, there's a caveat lodged by the seller. Okay, so they claim that they are aggrieved. So the court agreed, yes, they are aggrieved. Okay, so he has paid a full purchase price, but he cannot transfer property because of that caveat, is an aggrieved person. So this is a good example, okay, to show that an example of a aggrieved person. So court applied this principle of luggage test, okay, the luggage distributor, the 3-stage test, okay, whether to remove that caveat or not. So whether the defendants have a cavitable interest, okay, whether if yes, whether it is a serious question to be tried. Okay, so the court in this case that says the plaintiff had acted bona fide because he already do what he did, what he can. He already made all the searches, okay? Just before transfer, he again made the searches, I think 2-3 times searches that he made. He has acted diligently to protect his interests, okay, by lodging a private caveat. Okay, before the loan release, he also lodged a private caveat. After the SPA, she also lodged the private caveat to protect her interests. So I think she's already do what she is able to do in her capacity, okay, diligently. Next slide. So it's the defendant, the seller, who has not lodged caveat even after the plaintiff bought the property, okay, until December 2020, when the defendant may not have, okay, so the defendant may not even have cavitable interest as bare trustee, because please bear in mind, they have already received the full purchase price. So in what capacity they are to enter private caveat? Bare trustee does not have any more interest in the land, okay? So who had no longer had any interest because you already received the balance purchase price. So second question also answered in the negative. There was no serious issues to be tried, no issues to be tried. And the third stage, balance of convenience, okay? It lies to removing the caveat rather than remain the caveat. Okay, so in this case, the caveat was ordered to be removed, yeah? Next slide. Again, there's another case of Suntrack development. It's just a little bit different, okay, high court case also, where the defendant, who is a former director and majority shareholder of Company A, and a minority shareholder of Company B, lodged a private caveat. That means he lodged a private caveat in capacity of former director, okay, of Company A on the lands owned by plaintiff. So of course, plaintiff asked for removal on the ground that this defendant, former director, had no registrable interest. So the court in this case also applied the 3-stage test, yeah, whether the defendant, as a former director, had a cavitable interest or not. Okay, next slide. So defendants, when he entered, his reason for entering the private caveat is to protect the interest. Okay, he preserved the status quo. Okay, for the caveat to remain, because he was filing a suit against Baustate Holdings, against these two companies, Bhakti Virya and Baustate Holdings, who sold the lands to the plaintiff. Okay, meaning without his consent. Okay, so he claims that he is the real person who has title and interest in the plaintiff's land. So the plaintiff filed application to remove defendant's private caveat on the ground that the defendant had no cavitable interest. Next slide. So when the court applied this three-stage test, cavitable interest, no, okay, cavator is a former director, okay, which was sold off by the Baustate Holdings to the plaintiff, which the cavator, the former director, didn't agree without his consent, he said. Okay, bear in mind, this former director and company A, under the company law, they are separate entity, Solomon and Solomon, yeah. So defendant had no registrable interest, no cavitable interest, cannot enter that in his capacity as a former director of this company A. Okay, if this stage is negative, then the court is unable to proceed. Okay, when this three-stage test, remember, they have to pass first stage. If pass, the answer is yes, then only can go to second stage. If the answer is yes, then only they go to the third stage. Okay, that's how it applies, this three-stage test. So if the first stage, they can't even establish that he had a cavitable interest, so there's no need for the court to go to the second and third stage test, right? So no cavitable interest, sorry, the caveat has to be removed. Okay, next slide. Okay, so remove. Okay, that's what the court held. Next slide. So the takeaway is that, okay, in the application for removal of private caveat, the applicant must first satisfy the court that he is an aggrieved person. Two things must show the court. Okay, this is the case of where an aggrieved person vs cavitable interest. Okay, the person who is aggrieved, okay, the person who complained that he's lodging private caveat on my land, he must show that he's a aggrieved person. Okay, basically, if the landowner is the one who apply for removal, if he say he's the landowner, basically he's already an aggrieved person. Okay, court accepts that if he's the landowner, but there are some other who's not the landowner, who's any other person. That person has to prove that he's a aggrieved person. Okay, so the court has to first satisfy first, okay, he's a aggrieved person. Once established that yes, this applicant is a aggrieved person, then the court will ask the caveator to show, okay, your side, what cavitable interest you have. Why the caveat that you lodged cannot be removed. Okay, he will apply the three-stage test. That's how it works out. That's how the process. So you must first prove aggrieved person first. Okay, the applicant. Then once if yes, then the burden shift on the caveator to show that the three-stage test. He must pass that three-stage test, then only he can remain. His caveat can remain. Okay, right? So that's the takeaway. I think that's all for my session. Okay, is there any question? And is there any question? Any feedback, comments? Okay, if not, if not, then you are feel free to email me, okay, or ask me later, or any questions if you have. Okay, that's all the session. I hope you benefit from the session.
Ms. Pui, I have one question. Just one question now. That three-stage test is done by the caveator or how? Or by the court or by land office or how?
This one is court.
By court.
For removal, when you apply to court for removal.
Understand.
So you must, this 3-stage test, you must first pass one by one.
Mm.
You cannot just pass one and then remove, cannot. It means if these all 3 stages you can't even pass, the caveat has to go lah. The caveat has to be removed lah. Okay. So how strict? Because you must know the reason. Okay, you go and lodge other people's caveat, people cannot enter any dealing, no. Okay, once there's a caveat there, okay, and any land, you can't have any dealing with the land. So there's how severe consequence to the landowner. So the court is very strict. Okay, if you want to lodge a caveat, you must have very, very good reason. So you must pass this 3-stage test, then only it will allow the caveat to remain.
Okay.
Okay, this court is very strict. You must pass this 3-stage test. If you can't even pass test number 1, the first stage, whether the caveator had cavitable interest, then sorry, the caveat has to go.
Okay.
Okay, you understand the rationale. Okay, you are restricting other people's, the landowner's rights to deal with his land. No. That's why with private caveat, you cannot simply enter. Right?
Okay.
Any other questions? If no, okay, I thank you for all who attends. All right. Later we'll still upload this to YouTube, then hope to benefit more people. Okay, thank you for attending. See you again.
Okay, thank you.